Hello friends, in the series on the income tax cases, today we will discuss a very interesting case regarding the amount received by an assessee from his partnership firm which has been given to her as an arbitration award, and it was in respect of his relinquishment of right into the partnership firm. The question before the Bombay High Court in the case of Ramona Pinto versus Deputy Commissioner of Income Tax and another was that whether this amount is taxable or not. This case has been reported in 464 ITR at page number 305 and the date of the judgment is 8th November 2023. As I have told you that this case is very interesting, the facts of the case are very interesting. In this case, the assessee is a female assessee and the assessee has a share of 20% in a partnership firm. In 1997, the father of assessee died and the share of the father was 5% in the partnership firm, and the assessee was also entitled to this 5% share as per the documentation available. Meaning thereby that now the assessee was partner in a share of 25% in the partnership firm. In 2005, the assessee came to know that the assessee is no more a partner in the firm because of some arrangements by the other family members who were partner in the firm. So he challenged his share in an arbitration, and the award from the arbitration was given in favor of the assessee of an amount of rupees 28 crore. This amount of 28 crore was received by the assessee. The assessing officer issued notice to the assessee under section 148 by giving the reasons that this amount was taxable. But the assessing officer has not mentioned in those reasons that how this amount is taxable and under which provision this amount is taxable. The assessee filed the objections. The objections were disposed of, and even in those objections, the assessing officer grossly failed to demonstrate that how this amount is taxable in the hands of the assessee. The assessment was completed. This amount was added to the income of the assessee. The assessee lost his case in CIT appeal and tribunal, so the matter was before the Bombay High Court. When the Bombay High Court heard the matter, first of all, the Bombay High Court was of the view that in the present case, the jurisdictional requirement on the part of the revenue to demonstrate that how this amount is taxable lies on the department, and the assessing officer has grossly failed to demonstrate in the reasons and in the order which was given against the objections filed by the assessee. Nowhere it was mentioned that how this amount was taxable. The department was contesting the case on the point that there is no mention of retirement in the arbitration award and there is no positive balance of the assessee in the partnership firm. For this, Bombay High Court said that although there is no mention of retirement in the arbitration award, but from the facts and circumstances and from the dispute, it is very much clear that this amount has been received by the assessee as relinquishment of his right in the partnership firm. And the court said that it does not make any difference that the assessee do have any positive balance in the partnership firm, because the valuation report given by the assessee regarding the valuation of the assets of the firm clearly show that the valuation of the assets is near about 100 crores. Further, the court said that this amount can also be related an amount to be received on inheritance. The court said that even the section 45 subsection 4, which talks about distribution of capital assets or the taxability of the amount in case of distribution of capital assets. So the court said that in the present case and for the relevant assessment year, In the present case, there is no distribution of capital assets. So section 45 subsection 4 can also not be invoked in the present case. The court further said that this amount is not taxable as per section 56 subsection 2 clause 7, because section 56 subsection 2 clause 7 takes those amount taxable which has been received without consideration. Since this amount has been received on inheritance, so even the section 56 subsection 2 clause 7 is also not applicable. The court said that section 56 subsection 1, which talks about other income, an amount can be taxed under section 56 only when the amount qualifies the definition of income. The court said that every receipt cannot be termed as income and every income is not taxable. In the present case, since the amount has been received as an arbitration award and as per the provisions of section 2 clause 24, 45 subsection 4, section 56 subsection 2 clause 7 and section 56 subsection 1, this amount is not taxable in the hands of the assessee. At the end of this video, once again I am repeating the name of the case. The name of the case is Ramona, Pinto versus Deputy Commissioner of Income Tax and another, and this case has been reported in 464 ITR page number 305 and the matter has been decided on 8th November 2023. Thank you friends.